Hello, and welcome to this joint webinar hosted by the Central European University Democracy Institute, as well as the Bingham Centre for the Rule of Law. The title of our event today is Rule of Law at a Crossroads, the Walesa judgment as a catalyst for rebuilding judicial independence, with a question mark. I should introduce myself first. I am Dr. Oliver Garner. I'm a research leader in European rule of law at the Bingham Centre for the Rule of Law in London, one of the co-hosts of this event. And I also have an affiliation with the CEU Democracy Institute, where I am the editor responsible for the Rule of Law section at the Review of Democracy, RevDem. And I'm also the managing editor of the CEU Democracy Institute Working Paper Series. I will introduce my fellow panelists, starting with the co-moderator of the event, Barbara Grabowska-Moros, who is the lead of the CEU Democracy Institute's Rule of Law Clinic, as well as being a member of the Rule of Law Work Group. Next, we have Marcin Mrowicki, who is a member of the Ministry of Justice in Poland, as well as affiliated to Warsaw University, and he's currently a Reconstitution Fellow. Then we have Katerina Zipolova, who has her affiliation at Masaryk University in Brno in the Czech Republic, Czechia, who is also a Reconstitution Fellow. And our final panelist is Małgorzata Żuleka from the Helsinki Foundation for Human Rights in Warsaw. And I had the pleasure of meeting Katerina, Małgorzata, and Marcin at the recent Reconstitution Alumni Network in-person meeting. So it's a pleasure to welcome you to the event. I'm going to provide a brief overview of what the subject matter is and what the aims of the webinar are before I hand over to my colleague, Barbara Grabowska-Moros, who can go into a little bit more detail about the Walesa case. So after the general election victory of the opposition coalition in Poland last year, we have a situation in which Poland can perhaps be regarded as the first test case for reversing rule of law backsliding within the European Union. Many of the people who are participating today in this webinar have been involved in that commentary that arguably started in 2015, in Poland at least. From 2010, we had perhaps the start of backsliding by stealth in Hungary. And so, by contrast to Hungary, Poland has seen the victory in an election of a coalition of parties who have committed themselves to reversing rule of law backsliding and restoring the fidelity of the state to the EU's values. That's the broad context. Perhaps I could hand over to Barbara, who can introduce this very specific judgment of Walesa and the context behind our event today, and particularly this deadline of 25th of November. So Barbara, I'll hand over to you.
Thank you, Oliver. Good evening to everyone. Walesa is one of the most important ruling dealing with the rule of law. It was issued last year in November. The case concerned originally a defamation civil lawsuit, which eventually was decided by the new extraordinary chamber at the Supreme Court, and that was basically the main core of the argument presented by before the European Court of Human Rights. So the case concerned a claim that the court was not established by law as it is required by Article 6. And this is exactly what the court found in this case. Additionally, the court found all issues concerning the defective judicial appointments in Poland resulting of the so-called judiciary reform. They do result in a systemic problem which requires a systemic solution. That's why the case was decided under Article 46 of the Convention. So it is a pilot judgment in which the court set 1 year deadline for the government to introduce changes required in order to to re-establish the situation which would be compatible with the convention. And as we all know, the issue of independence of National Council of Judiciary and also lawful judicial appointments, it's a very broad topic, which is also a topic of political debate currently in Poland. We thought it requires also some sort of assessment from the legal perspective, but also from those actors who are stakeholders of this debate and try to oversee what is happening with the execution of the ruling. The latest update from last week is that the court decided to prolong the deadline of fulfilling this pilot procedure. So the debate about execution and implementation of Wałęsa case will be continued for the next 12 months. One of the reasons is the fact that there are no political possibilities to introduce the new legislation. This is at least something which was presented by the government in their action plan submitted to the Committee of Ministers of the Council of Europe last March. We also have a Venice Commission opinion which tries to discuss in a general way what would be possible options in terms of introducing legislative amendments, especially in terms of assessing the status of the judges who were appointed after 2018. So basically the status of whom will decide whether we can say about the judiciary being established by law, the court being established by law, which is required by the convention. I think this is the point when we can start the discussion about Wałęsa case to see what is really happening with the implementation process and what are the major limitations and obstacles and difficulties in implementing the ruling.
Thank you so much, Barbara. So I'm just putting a point of housekeeping in the chat to outline to the participants how we plan to run this webinar. So first, we're going to have a round of questions pertaining to the judgment and the broader context from myself as one of the co-chairs to each of Marcin, then Małgorzata, then Katerina. Then we'll have a second round of questions led by Barbara. And then after the answers and the discussion, we can come to Q&A from the audience. So we're very happy for you as audience members to type your questions into the chat. And then we can either come to you directly on video for you to ask your question to the panelists at the end, or one of us could pick this up if that's not possible, or if you would prefer. But to move on to our first round of questions to the panelists, Marcin, if you don't mind, I have an initial question for you, which is on the direct point of implementation of the Wałęsa judgment. So the question is, what are the main legal rather than political obstacles or difficulties in implementation of the Strasbourg Court judgment? And then I suppose a follow-up would be, to what extent has the judgment already been implemented, and what current legislative work is occurring within the machinery of Polish government to address this? Marcin, the floor is yours.
Thank you for inviting me to this very important conference. I would like to share my thoughts concerning those legal obstacles, although the political are well known probably to most of you. The most difficult problem is, first of all, the unprecedented situation. I mean, we are dealing with more than 3,000 judges that were nominated in the deficient procedure. So this situation was never faced by any other European country. Yes, all the vetting processes that we checked were mostly unsuccessful. They considered corruption cases. Other countries that wanted to follow examples, for example, of Albania, they stopped the idea of vetting, seeing what happens to judicial proceedings and how all the proceedings were stuck, lengthy, and there was like vetting didn't change anything. Yes, so we are dealing. So this is the situation. We can compare our situation to Iceland. but Iceland dealt only with four deficiently nominated judges, yes, and the execution of this judgment was very easy because all those four judges, they ceased to adjudicate. So there were four vacant positions that were, during the competition, they were filled. So the situation was like everybody understood what happened. So unlike in Poland, that judges, although they understand, so-called neo-judges, although they understand that the court adjudicating with them on the bench might not be the court established by law according to the convention. They did not cease to adjudicate. This is the difference. And so we are talking about the different scale and different problems that weren't so far tackled by anybody. Yes, that was the reason why the Polish government, namely Minister of Justice, asked the the Venice Commission. And also this is why there is a codifying committee specifically established for this kind of issues like restoring rule of law in judiciary and prosecutor's office. And there were, of course, different ideas that we are talking about how to approach this vetting process, and still it wasn't clear. That's why we asked Venice Commission to have a base at least on what are the European standards according to the Venice Commission. Yes, it was also challenging, I think, for the Venice Commission to approach this problem. And as you could see, also the Venice Commission, what it did was to a little bit cover behind the questions, because they reserved the answers to certain questions, showing that the questions might not be accurate, or So this was the position. So this is very complex legal situation, and I think that despite the Venice Commission opinion, the legal reality in which we will be, I think, the next year will be still something new and very challenging for every constitutional lawyer. Yes. So coming to the point, what was done by the Polish government so far? Yes. So in order to execute Wałęsa, first of all, we had to and it was one of the first legislative project. It was project concerning National Council for the Judiciary, which unfortunately, after the legislative process was sent by the president to the Constitutional Tribunal. Yes, this is what is happening with all legislative acts, and the same happened to the act concerning Constitutional Tribunal. Yes, so this is what happened. So still, without this political change, any legislative effort would be in this way stopped. So this is what was done concerning National Council for the Judiciary. But if we are talking about status of judges, yes, so now the codifying committee that had already specific ideas how to approach the problem has to change it and apply the standards that were somehow defined by the Venice Commission. So we are now on the phase of the work of the codifying commission that is adapting those standards to the new project. And so what will be changed? It will be this procedure concerning the reassessment of judges, authorization of judges as regards their status. And of course, the Venice Commission allowed a possibility, although the individualized approach is required, that certain groups, that those judges could be grouped according to certain factors. So I think this was what will be done. So the new legislative project will be indicating the principles how to group judges, and they will be namely selected to every group by the future legal National Council for the Judiciary. Yes. And those people who, so we have to separate it from disciplinary proceedings that will be held against those who, in specifically important way, acted against rule of law in Poland. Yes, so this is the concept, and I think that according to what I've heard from the minister, the project should be ready in January, February next year.
Thank you so much, Marcin. It's very interesting to hear you say January or February next year, because, of course, one of the broader points of democratic context is the upcoming presidential elections. And you alluded there to the presidential veto, which is, of course, a barrier to legislative action. I mentioned very briefly, it's interesting you made a comparison to the Albanian case. One of our colleagues at the Bingham Center, Dr. Yulinda Becherai, worked quite closely on the ground there. So very interesting to see those parallels being drawn, especially as Albania is a candidate state for accession to the EU. But you also mentioned there, Marcin, the Venice Commission's opinion. So I'd like to come to Małgorzata now. Małgorzata, of course, in your role at the Helsinki Foundation in Warsaw, you're part of a key NGO engaging on these issues. So could you perhaps remind or inform our participants of what the Venice Commission said in its opinion about the implementation of Wałęsa, and also about the broader point of restoring judicial independence in Poland? And why also was the opinion criticized by certain actors in Poland? I think amongst them, some actors who may be close to government. And finally, how would you assess the last year in terms of the implementation of the judgment?
Well, first of all, good afternoon, and thank you for the invitation. Thank you for having me. I tried to write down your questions, Oliver, but I'm pretty sure I forgot the third and the fourth one. So please feel free to me when I'm going to derail my answer to your questions. As Oliver said, I represent the Helsinki Foundation for Human Rights. We are Warsaw-based human rights organization, and we've been following very closely the rule of law crisis since 2015 in terms of monitoring, research, documenting the crisis, but also providing legal aid to judges and strategic litigation. And for the last couple of years, we are also deeply engaged in the discussion in the judicial and legal community on how to address the biggest problem right now, which is the status of the so-called new judges. So first of all, let me just say that we absolutely welcomed the Ministry of Justice initiative to ask the Venice Commission these abstract questions. Because one of the things we are seeing right now in the broader process of the rule of law restoration is that because of that hostile institutional environment in which the new government took power last year, and also the Constitutional Tribunal and the political forces, which is still the incumbent president, it is quite difficult to strategize and to sequence the process of the rule of law restoration. So for that matter, the move from the Ministry of Justice to ask the Venice Commission before any concrete legislative proposals are being put on the table, it was a very wise move in that sense. Now, when it comes to the Venice Commission opinion itself, when you read it, you can see this predominant, I would say, approach from the Council of Europe institutions that they do recognize the problem, but at the same time, they really don't want to open that Pandora box. And the hints of that approach are already sparkled in the Wałęsa case judgment last year, when by the end of the judgment, the court put it very straightforwardly that it's not the role of the court to suggest the solutions to that problem. And the same is with the Venice Commission opinion, where the provided answers are very much focused on the asked questions, which is on one hand quite logical, but at the same time you can see in the opinion there's some sort of the self control from the rapporteurs drafting the opinion of not going too wide. And to that I would just get in a second. So first of all, the biggest was that, and that was the bone of contention among the legal community, is what kind of model to choose to address what Marcin called this problem, which is the addressing the status of the new judges. And here I think it's important to make the disclaimer, because it's usually presented both at the domestic and international level that there is some sort of an argument between judges and lawyers on those models. And to that I oppose, because when you look at the entire discussion, we very much agree on the diagnosis. We also agree on what should be the end game. The discussion right now and our position in the discussion is to what kind of method to choose in order to address the problem. And from the perspective of Helsinki Foundation, we don't represent anyone's interest. Our only interest and only priority is to secure the process, to make it sure that it's bulletproof from the rule of law and human rights protection point of view. So now, coming back to what the Venice Commission said. So first of all, the Venice Commission had verify, or maybe not verify, but analyze the problem, whether it would be possible to declare all of the decisions of the politically captured National Council of Judiciary null and void since 2017. And this is I would say, the core of one of the proposals on addressing the status of the new judges, which is based on the assumption that the so-called new judges are not judges at all. Hence, they should not enjoy the safeguards of the judicial posts, such as, for example, irremovability. And for that matter, that such a declaration would be possible. We oppose that statement, and the same said Venice Commission, claiming that declaring it ex lege and in an automatic process would be contradictory of of course, this is just the one layer. Look into that. It's also a layer. Sorry, my internet, my Wi-Fi connection is very unstable. Can you hear me?
Yeah, so you are breaking up slightly, Małgorzata. I wonder if it continues to persist, maybe one option could be indeed to stop your video, and then at least we can hear your contribution.
Okay. So let's carry on like that, and once it becomes insufferable, let me know.
That sounds good.
Where were we? Declaring the motions of the National Council of Judiciary null and void. And the Venice Commission, in its opinion, very clearly stated that such a ex lege automatic process would violate the rule of law and the democratic standards to that extent. And the Venice Commission also, in that sense, opted for the individualized authorization, but it also had to find a proper balance between, on one hand, verifying all of those, by our account, 2,500 decisions, and at the same time not risking the entire collapsing of the judiciary system. Hence, they also suggest the idea of cohorts, of grouping the judges into the cohorts, and some semi-automatic processes in some kind of those less contested groups. Here is, however, I see a little bit of I would say, deficiency of that opinion, because the Commission stopped itself without actually proposing those criteria by which the judges could have been grouped. That's the first thing. And the second thing is also, it still remains unclear to me who is going to decide on that. Should that be done in the law by the Parliament, or the new National Council of Judiciary should do it? I think the Parliament should leave a relatively wide gate open to that, but it would be up to the new independent National Council of Judiciary to decide on how those judges should be grouped. Maybe I would just stop here and just come back to your further questions on the how the opinion was received in the judicial community and in the legal community. And well, first of all, we expected much heated discussion after that, given how much discussion was done last year after the election when there was that eagerness and that willingness to address this problem very, very quickly. Right now, I was surprised that there were only a few, I would say, debates around this issue. And the second thing is that it's still unclear to me how the Ministry of Justice and the Codification Committee are going to fully incorporate the Venice Commission opinion recommendations or maybe answers to those questions. Martin generously talked about those ideas and frameworks for this regulation. However, we still haven't seen anything on paper after the year. So I'm very much looking forward to that proposal, and then I think that would beg for another meeting.
Thank you so much, Małgorzata, for that intervention. You mentioned there, I think, the point that perhaps speaks most to me as an outsider in terms of not being a Polish national is the fact that there is, as you see it, and I think others have seen it, this risk of a collapse of the judicial system. I remember having conversations in Brussels with friends of mine who were working in the EU institutions at this point, and this was before the election victory, this was 2022, and they pointed out the concerns that their friends and ex-colleagues had who had been appointed since Law and Justice came to power in 2015. And these individuals had a very real concern for their career. But of course, the issue in terms of the system is, as you pointed out, what could happen to the stability of the system if such wide-ranging changes were made. So perhaps we see a law in the books versus law in action issue, whereby if one were to really follow through with that reasoning that we've seen in court judgments from Strasbourg, you do find yourself in this situation. Yes, Małgorzata.
If I just may react to that at the risk of monopolizing the discussion, is that I think what is important to bear in mind for both the inside and outsider spectators of the discussion is that this problem right now is far from being just a legal problem.
Yes.
For the legal perspective, it's extremely complicated issue. As Martin said, no one has ever approached that before. I think in our research, we found only one case that could have been slightly similar to what we are saying, and it was in Pakistan 30 years ago. But for the rest of the world, it's really unprecedented. But it's not only legal. The thing that we tend to miss quite oftenly is also that it's emotional and psychological problem for judges too. And I do recognize many of the judges' trauma, those judges who were subjected to smear campaigns, criminal proceedings, disciplinary proceedings, and the fact of the unfairness that they decided to sacrifice so much of their professional work, whereas there were some judges who decided to seize the opportunity. That's for sure. But it's also a sociological problem. And by that, I also mean that right now, the Polish judiciary system is on the verge of existence in a sense that whenever we have clients going to the court, they usually wait at least 1 year for the first hearing. And for the lay citizen, when they have the life-changing case being decided by the court, it really doesn't matter whether this is a new judge or the old judge. They would rather have the justice being served. So we have this multiple perspectives into that process. And it's not only always beneficial for only the legal discussion, and we have so many factors influencing that. So what I'm saying here is that in order to fully implement we will need to look much, much broader than only the legal provision.
Thank you so much, Małgorzata. And I think your connection held up just long enough for you to make that final important point. And perhaps this could be theorized as what concerns what certain scholars have called the material constitution. As you said, it's emotional, psychological, sociological. But I think the material here is very important because it is about the functioning of the system in a very material sense, as you said, access to justice, issues like this. But we can perhaps move on now to the final question from this round, and that would be for Katerina Zipolova. We've heard about the domestic level here when it comes to implementation of a judgment of the Strasbourg courts, this Wałęsa judgment. So I thought we could maybe reflect a little bit on the ECHR case law in general. and also actions of the Council of Europe in more broadly, which of course includes the Venice Commission, the Commission for Democracy Through Law. So, according to you, Katerina, what are the strengths and limitations of the case law of the European Court of Human Rights in restoring and strengthening judicial independence? Katerina, the floor is yours.
Thank you very much. That's an incredibly complex question to target in a couple of minutes, but I will perhaps start where Malgorzata left, or how she concluded. One of the biggest limits to me is that we are now pushing some of very political systemic questions on judicial bodies.
Yes.
And that's not only the ECTHR, but in the end also Venice Commission, which composition is mostly judicial or judge-based. And we see this problem that a lot of the questions that probably are really of more systemic character are just viewed from the perspective of principles of judicial independence, which is completely understandable. And I do understand. And it's not only Council of Europe, that's also the trouble with the Court of Justice of European Union to an extent, and I'll start with courts. So to an extent, I do understand while both supranational courts in Europe are actually taking the principle of judicial independence to tackle these issues and questions, because they have a very limited authority and powers to otherwise adjudicate anything on this rule of law backslidings. And this is actually, maybe we'll come to that a little bit later in the discussion. You can see it very well right now in Slovakia, in the development there, where very narrow scope of rule of law backsliding is actually happening within the judiciary, and many other issues are happening in other branches of power. And suddenly we are missing the link, right? So we obviously, the courts are not agency setters. They are answering the questions that are submitted via petitions, but they did overstretch, in my opinion, the principles of judicial independence and how to actually get these questions under their own authority, interpreting the convention or interpreting the EU treaties. Why do I think it's a problem? And I think this is a problem that you can read in the Walesa case, and you can actually read it in the rest of the case law that ECTHR produced on the situation in Poland. So on one hand, if you read the case, the court identifies these general measures, right? So the court sort of says what are the issues that Poland and the government needs now to address, like tackling the composition and reappointment of the National Council of Judiciary, address the appointment of judges that were selected or, sorry, appointed by the Council from 2017 on, and address their case law. The court says that it is not up to it to provide the solutions, which is completely rational and understandable. However, I do think that if you actually read carefully the rest of the case law, what they achieved by overstretching the principle of judicial independence is that they actually limited the options of the government on what now would be considered to be the rule of law binding solution to the crisis. A lot of the case law, starting actually with Greda case, tackles the question on the future composition of the National Council of the Judiciary, for example, which I do find problematic. And again, mostly because it is perceived from the perspective of judicial independence being transposed to other bodies, not only courts and tribunals, like judicial governance or self-governance bodies like National Council. So what we basically can read from the case law is the return back to the idea that in future these judicial councils need to have at least half of the composition should be the judges. They should be elected by their peers or selected by the peers, which actually is something that we have no empirical evidence that would be working correctly. The same goes with the principle that the judicial independence is somehow transposed also to these judge members, or sometimes if in some cases the ECTHR is actually not careful enough and somehow equalize or transposes the principle of judicial independence to the whole judicial council, which is very problematic because we already know from experience of Central and Eastern Europe that judicial councils need to be absolutely independent from the judiciary itself as well. They simply need to be bodies that are autonomous and that have no or they are obviously bound by principles of independence and accountability, but to all three branches. And we know that if judges have a lot of say and a lot of impact on judicial councils, it can be actually problematic and backfire. So one dimension to me would be this problem that all these issues are always looked at via the principle of judicial independence, and the rule of law questions are sort of limited and narrowed down to how the courts are able to interpret judicial independence. To me, many of these questions are way more systemic and require a more careful reading of the separation of powers and the rule of law, which, however, obviously goes beyond the scope of the convention. And I do understand why the court was not able to get there, but then it created a lot of the expectations that would be very difficult to fulfill. Same, the court, another dimension would be that the court on one hand says that it's being left to the government to decide, but then we do know already that the appointed judges are considered to not fulfill the requirements of tribunal established by the law. We know from the CJEU case law that the newly appointed judges are to be considered as non-judges. So actually there is not, I mean, the scope is getting very limited for the government what to decide. And I know that many scholars are suggesting that given that, and as Martin said it at the beginning, we are talking about a lot of judges. We are talking about the very systemic changes that are going to destabilize the judiciary. And I wonder whether this should not be perceived more from the perspective of transitional justice theories, that you should give a little bit more leverage to the country itself to actually decide how to untangle these problems, looking more also to broader societal questions, right? It's quite easy to say that the judges appointed by the new council are not real judges, but then what's really going to happen with the case law? Like, how are you going to tackle all these thousands and thousands of cases that were decided by judges who were not legitimately appointed? And we do have, I mean, I completely understand the difficulties. We do have some examples of what potentially can be done with different discipline, vetting, retention elections, affirming some of the elections of the judges. But I do wonder whether they would be actually compatible with what the court, the ECTHR, said already in its previous case law that a little bit overstretched, in my opinion, the principle of judicial independence. And I will conclude with that because we will have chance to go more in the individual questions. When you're asking about the ability of these bodies to actually strengthen judicial independence or stop backsliding and similar crises, I would actually be very skeptical. I mean, it does help. It definitely does help. And one of the great things we have seen was the ability of European judges to somehow to really manifest their ability to trigger attentions of international actors. That's something I feel that right now when we have attacks on the journalists, on media, on prosecutors, I think they don't have such a potential to trigger core institutions inside of Council of Europe or European Union, and you can really see different treatment. So here having these very strict, very forceful judgments was definitely to an extent helpful. But on the other hand, you can also see that and this is not only about Poland, but crisis happening in Hungary, in Romania, in Slovakia, to an extent in Spain, you can actually do very little aside from the fact that you have a symbolic judgment, sometimes even forcing the government to undo a piece of legislation. Like once, I think that the major problem, and I do think that courts are not able to tackle it, the major problem is that once the government is quick to undo an institution and completely abolish it, to change the personnel of the institution, there is actually a very, very little supranational court as a judicial body can really do to ever establish that. So I would rather be bit careful, have limited expectations of what all these supranational courts can do, but be very careful in how they stretch the rule of law and judicial independence. I think that more careful reading of judicial independence and rule of law principles, not stretching it to those institutions that are inherently different. The judicial councils, to me, are not judicial bodies, would actually be more helpful in future guiding the countries on how to restructure their judiciaries.
Thank you so much, Katarina. There's so much there that's so rich for intellectual and practical discussion. I think there are themes of legal constitutionalism versus political constitutionalism. It's fascinating to hear conversation about how judgments from supranational institutions maybe stepping into a void has now potentially limited the political space once, in a sense, the issue was resolved through democratic elections. There are some very interesting legacies that have arisen from this very active case law of the Court of Justice of the European Union. And I would just say that I think there's a lot more debate to be had on the work that's been done by the Court of Justice under President Koen-Lenaerts on instrumentalizing the values found in the Treaty of European Union in Article 2. But I think it's probably time for us to move on to Barbara. I think I just finish by maybe reflecting a little bit on the fact that the Bingham Centre for the Rule of Law are also engaging with the OSCE Office of Democratic Institutions and Human Rights, conversations around judicial appointments. So this is an area that we will be pursuing in the future, building on our engagement on the Constitutional Tribunal around the time of K621. So, Barbara, I'll hand over to you for the second round of questions, and I look forward to the further conversation.
Thank you, Oliver. I think I would start with one of the points that Katarina mentioned, and that dealt with, triggering international attention. So I think one of the success, I think, of judicial community in Poland in the recent years. So they were able to mobilize themselves, but also mobilize their actions and create something which is discussed as either mobilization or even judicial resistance against the backsliding. We discussed Wałęsa case today, but in another famous case, Żurek, the court says it's not just a right of the judge to speak or protest against, by speaking, oppose the attacks against judicial independence, but it's also his or her duty. So I think the discussion about judicial resistance really received also highlight and recognition in the ECHR case law, and this is something which is super important for the Rule of Law Clinic working at the CEU Democracy Institute. So we really look at the rule of law as a living concept and not just theory and law in books. So I was thinking that let's concentrate in the second round of questions exactly about, let's concentrate on the judicial resistance, especially because two of our speakers have published a lot about exactly this topic. So I would start maybe with Marcin again. You have just published a book, All Rise: Judicial Resistance in Poland, in which you analyze basically what happened in the last years in terms of judicial mobilization, judicial resistance in Poland. You discuss, methods, obstacles, consequences, also costs paid by individual judges, but you also try to present some sort of takeaways for stakeholders. So and then you divide and analyze the topic from the perspective from judges, academia, also other activists. Could you please elaborate a little bit on this? Meaning, could you present what are the key takeaways for the judges, but in a different perspective now? So in the perspective when we try to rebuild the rule of law foundations, how do you think what the lessons could be learned by the judges in a situation when now the task of judiciary is to rebuild or participate in rebuild the rule of law fundamentals?
For such a kind introduction. Let me start with, I presented this book a week ago in Tel Aviv, where I am currently, to exchange with those law professors that were engaged in this resistance against judicial overhaul in Israel. And their reaction was to what happened in Poland it was fantastic, but not fantastic in a way amazing, but fantastic in a way fantasy. How can you imagine that judges were protesting on the streets and were engaged in so-called resistance movement against this unprecedented attack on their independence and rule of law? Yes, they said that they could not imagine such situation in Israel. So they were like listening like to sci-fi story about what happened in Poland, and hard to believe that it would be repeated in Israel. Yes. So first, second of all, I would like to say also what is very important to understand in terms of addressing status of neo-judges. One of the form of resistance of judges was, first of all, boycotting promotion or nominating selection process before the National Council for the Judiciary in two ways. First way was not to write opinions. The judges' assemblies, they resigned from producing opinions concerning nominations because they said that the procedure was contrary to law. So everybody from the beginning knew that this procedure was not was deficient. Yes. And secondly, what was more important and what was mentioned already by Małgorzata is that judges boycotted at all. Most of judges boycotted the nomination process. Yes, they said, no, it's not good for our careers. It's against the values, against the constitution, etc. Yes, there were different reasons behind that, but most of judges, they did not participate. So, and this was the form of resistance, yes, to boycott such selecting process. And then coming also, I thank you, Katarina, for what you said about this kind of the approach. I also believe that we don't have standards that would fit the situation that we are having in Poland. And afterwards, probably because I know that there are now so-called neo-judges that are looking for help in the European Court of Human Rights, that will have in future judgments concerning their status. Yes, so it will be for sure in probably not soon, but probably it will be dealt with by the European Court of Human Rights. But we asked Venice Commission, taking into account the fact that the standards that are applied, in fact, can hardly be given to such a situation. Like, how can you bring these standards, which were in different kind of situation, to such a scale and such a difficult situation? So just a comment. Yes, coming back to the takeaways for judges. Of course, most of the takeaways were during the situation of democratic crisis. Yes, but some of them are just practically same for every judge everywhere. I think that judges must transform into so-called people's judges to connect more effectively with ordinary citizens. Yes, so it was said that applying to what the European Court of Human Rights said, judges should not remain silent. The question is who should speak. And of course, we can say that there are judicial associations that should be involved in the public debate to defend judicial independence. But also we have to take into account that judges are the third power. And this is very, like we can say, they are very powerful because they have tools that other powers do not have, like judgments and also referrals to international courts, etc., that they used to defend their stance, to defend their position. Yes. Second of all, and this is, I think, crucial in order to build some sort of confidence or trust in judiciary, is that judges must change their attitude in the courtroom. And what was striking for me during the exchange with the Ministry of Justice in the Netherlands, the trust in judiciary in the Netherlands is about 80%. And the reason why is that there are many reasons, of course, but it's the approach of judge to the parties, that this is a very friendly environment where you are dealing with very stressful situation, but approach of the judges is trying to help parties to go through the proceedings, which is completely different to the judicial culture that we have in Poland, that requires reform and change of stance. Yes, so this is very crucial in order to change the way the judges are perceived. And judges, of course, have, of course, one of the instruments, and it always will be, certainly, it is used now in Poland when there is no constitutional tribunal that could be relied on, is adhering strictly to the constitution and international law. But it was even before the crisis, human rights lawyers applied for such application, because it is required by the constitution to directly apply the law, international law. Yes, and judges should utilize all procedural opportunities, ensuring no case is overlooked. They should prioritize legal education to cultivate the belief there are some sort of legal foundations that engage judges to show how they are working, inviting them to the trials and showing the work of the judge, in order to be somehow connected with the society. It is very important because we also saw that in the populist playbook, one of the first aims is to limit the judges' independence, the judicial power. Yes, and of course, one of the very critical takeaway is the judicial association and the opposition. Yes, and I wrote that judicial association should emulate the operational structure of trade unions, because I think that people that are publicly engaged representing judicial environment should be maybe more involved in so-called representing judicial interests, not judging. Yes, it would be like giving them positions in judicial association would also help to find a balance between the engagement in public and, of course, and judging. Yes, so these are the most important takeaways.
Thank you, Marcin. I was thinking maybe let's move now to Katarina and to paper which she published recently. The Light and the Dark Side of Judicial Resistance was published in Law and Policy Journal. I think the paper is super interesting. I think it should be absolutely read by not only by academics but also by judges. And here you present a really comprehensive picture of exactly the light and the dark sides of judicial resistance. And I was thinking, let's concentrate now a little bit on the dark sides. And could you please discuss a little bit this part of your research? And I was thinking, trying also to connect with what Marcin said, this idea about kind of transforming judicial associations in a sort of trade unions. It sounds like a potential source of challenges for judges and judicial independence. So I would stop here, and I'm really interested. How could you comment on that one?
Sorry. Thank you, Barbara, and thank you for your kind words. So I'll try to explain the concept, how I meant it. Firstly, so for me, what I suggested is that even the resistance or resilience, or let's leave now resilience aside, but when we talk about resistance and different strategies judges can employ, they are not necessarily normatively neutral. Sometimes you can have resistance that aims to help and strengthen the judicial independence, democracy, or let's say resilience of other democratic institutions, but it can very well be purposefully misused, or it can create troubles and issues for other democratic institutions in the long run, right? So what I was basically saying is that first, if you look differently at how judges resist from the short-term, mid-term, and long-term perspective, then and this article was not about Poland. I tried to collect different examples of resistance of judges all over the world, and then you can very clearly see. So this is not very helpful for the Polish example, but sometimes in many countries, for example, a close collegiality and let's say almost friendly relations and close relations between judges and politicians are actually very helpful for many judges and many judicial systems, because um, they can actually help to protect the judicial systems from some of the controversial reforms. But then the question is what it really means for the long-term public perceptions. But even the issues like judges marching in the streets, or judges suddenly being very vocal, very critical, what effect would be of this for the long-term concept of judicial independence, public trust towards the judiciary, and confidence in courts? The midterm perspective would be also, and that's exactly what Marcin was saying, that when we think about resistance and ability of judges to resist, it's not only about the active strategies they are implementing, but this inherent embedded ability to understand what democracy is, to be able to quickly identify that something is a threat, that they have to choose to either resist and still abide the rule of law, or whether they can risk and try to resist and go against the principles of the rule of law. But mostly it's to me about this further education, ingrained principles that if we are judges, we have certain role in democracy, what this role in our particular separation of power system is, how we are able to withstand the pressure, right? If we identify that something is a threat to democracy, then what do you actually need to do in order to make judges feel that we as judges are able to stand against the upcoming political pressure? But then that goes to other side of the judicial resistance. I do believe that, and this was hinted by Oliver, that one of the issues will definitely be that resistance can be done by those judges that are on the good side of rule of law and democracy, that are trying to resist the political pressure. But for sure, we will see the same strategies often used by those judges that were appointed by or under the rule of law and justice, and they will try to oppose the new incoming reforms, right? And some of them might feel that they did nothing really wrong, that they are not politicized. And I do believe that there will actually be many judges that did not act actively against the rule of law. And the big question, obviously, for the new government would be to what extent you need to get rid of those judges that actually do not have active transgressions, right? And then another question would be whether some of the protections and safeguards of judicial independence we now have developed on the supranational level would not help these judges to actually still claim that they have certain rights to continue executing their mandates. Well, some of the very obvious strategies, like using judicial review, that's exactly how we started the webinar. And we can see that Constitutional Tribunal is basically executing the very same resistance strategies we would have liked to see executed by the Constitutional Tribunal, perhaps back in 2015, and it did to an extent, to be fair. The more complicated question would be, because it might seem easy to say that, well, now we have this case law of ECTHR and Court of Justice of European Union claiming that they are not judges, so what claim they should have to actually execute their mandate in state power? But it will not be that easy, and the longer it will take to execute any reform, the more complicated it will become, because some of the appointed judges will for various reasons might not be judges anymore. You will feel the, so let's say that we would have judges appointed by the Judicial Council under Law and Justice Party, but their positions might become empty, filled with new judges, right? So how are you going to evaluate those? And this situation will definitely happen, because we know that it will at least happen in the institutions like Constitutional Tribunal. So does this concept of judge that was not legally appointed, will it actually travel to another person that was appointed to the position that was actually emptied afterwards? Do we have a clear-cut answer from that? Are we not actually going to arrive to the issues that some of these persons will legitimately resist, and they will have the claim that would now be protected by very strict judicial independence safeguards that were, as I said, developed at the supranational level? So that's what I understand, that we need to be careful because even judicial resistance can actually be used to the detriment of democracy. And not every resistance we see is actually helpful for democratic institutions. The one way how I see it damaging is if the strategies are used and utilized, and they are often successfully utilized in other countries by those judges that were actually helpful, or if not helpful, just served under the undemocratic regime. The other problematic issue is if we can identify that some of the resistance strategies were actually violating principles of rule of law. And in our previous email exchange, you posted very interesting questions, like to what extent it would be problematic if new incoming judges right now under the new government would later on be deciding on independence or dependence or disciplining those judges that were actually selected under Law and Justice, right? So thankfully, Poland is a relatively big country, and I can imagine that even if some judges would need to recurse themselves, you might still find some solutions how to actually do that. But it's indeed a very problematic question. Again, we are not opting for political solutions, but we are leaving a lot of these questions to the judiciary itself. A lot of these very problematic transitional questions will be only dealt through the sort of as if you involve judicial self-governance to clean the judiciary itself. And my skepticism would be that, again, we know from many countries, especially in Central and Eastern Europe, that it is not working very well. And I do think that to an extent, the political legitimacy to decide what to do with these judges might actually be higher than if you only leave it to the judiciary itself. The judiciary will be sifting the bad apples and stating to what extent the judges are liable, legitimate, etc., etc.
Thank you, Katarina. I think just yesterday or 2 days ago, there was a press release from the Parliamentary Assembly of the Council of Europe about the monitoring mission to Poland, which dealt exactly with judicial independence. And one of the sentence in this very brief press release really brought my attention because it was underlined that there is a huge polarization in the country, not only in the political environment, but also within judiciary itself. I fully agree with this statement. It's absolutely, it names one of the problems which exists in the country. And I think that would bring me now to Małgorzata. And now the question would be not about judicial resistance, since Helsinki Foundation it's not judicial association, but it's a watchdog organization apparently. And now that the transition to the rule of law, rebuilding the rule of law principles, I think it poses another set of challenges, which was completely different or might be completely different than those which civil society could face in the recent years. But those are, I think, quite important ones. And as Katarina mentioned, in this resistance strategies, one of the option which now is exercised by the biggest judicial association in Poland is idea to draft a legislative draft and to discuss it in public. This is something which was not done by the Helsinki Foundation, but instead you published a kind of a policy report, a kind of a report which discusses exactly what are the possible solutions, options for dealing with the new judges appointed after 2018. Could you please discuss what's in the report, and could you please discuss exactly my first question? So, what are the challenges for the civil society here in this new situation?
Thank you, Barbara. And again, I'll try not to jeopardize the Wi-Fi connection. Maybe I will start with your latter question on the challenges, and then I will move to the policy paper you mentioned. I mean, the beauty of being the watchdog organization means that whoever is in the opposition somewhat leans towards you, and out of a sudden, all the opposition politicians know your email address and your phone numbers, and they are very eager to reach out. But whenever they take power, they out of a sudden see you as the enemy, or at least as I would say, not very constructive interlocutor. So the challenges for us is, first of all, rebuild that participation muscle. One thing we tend to forget when we talk about the rule of law crisis in 2015, 2023 was that it in fact influenced not only the independence of judiciary, but entire democratic standards. So, for example, any kind of social consultations or any public discussion with the authorities was impossible simply because we were excluded from that dialogue. Right now, the ministry and different government authorities and the parliament itself is very open to that process, and the social consultations are way better than they used to be in the period of the last 8 years. So this is definitely a sign of progress. There is, however, a challenge into that because we still have to reinvent the process of the social consultations or at least make it better. So, for example, it would be good to have report from each of the stages of the consultations to know better, for example, how the laws are being drafted, not only in terms of what kind of draft legal provisions they contain, but also whether there has been done a proper assessment of the planned changes. And this is just coming back to my previous point, how huge will be the operation of the reauthorization of the status of judges. But another challenge, and which I am observing, and which is an overarching trend, which is already picked by several researchers, is the so-called democratic hypocrisy. And the researchers who are doing extended studies on the populism in Poland caught up this phenomenon of growing tendency among the supporters of the current governing coalition to less democratic or rule of law oriented purposes. So in order to achieve certain goal, there is a bigger tolerance which grew in the span of the last year for the less democratic approaches. And this is linked to one of the, I would say, things that the Prime Minister said earlier this year, this so-called militant democracy. In the political perspective, it is reference to the notion that all of the potential radical, not very rule of lawish methods are allowed in order they are aiming at keeping the populace at the bay. So for us, for the civil society organization, and again, the independent organization that tries to keep accountable all kinds of governments and all kinds of parties that have been in power for the last 35 years, it is not only difficult for us to verify how these new doings of the new government is in line with the constitutional and international standards, but also to explain it to the broader public why we are critical to some of the measures being adopted by this new government. Because we are usually confronted with the statement saying, why do you criticize this government? That this government embodies this promise of the democratic change. So what is your problem with that? So this is the problem here. And now the final thing that was hinted in your question, what is our role? We perceive our role as the independent experts, and the independent is crucial for us. So we don't see our role as presenting specific, detailed regulations as such or draft proposals for numerous reasons. First of all, we simply don't have that kind of access to, for example, statistical data, or we're not able to properly assess some of the super complicated legal and social problems. But at the same time, relying on our expertise on the constitutional standards and the international standards, we can offer a certain ramifications for some solutions. And the report you mentioned, the one which is called a judge or not a judge, is actually the perfect example of that. Because on one hand, in its first part, it presents the overview of the international and national standards of the judges' independence and the principle of irremovability, but also touches upon some of the examples that Marcin mentioned, so from, for example, Albania. But in the second part, the authors of the report, Marcin Wolny and Marcin Szwed, present a framework for what we called the individual sorry, there should be some more accent in that, but I really don't know where right now. Reauthorization of the appointment process of judges. So it first of all contains a list of, I would say, criteria or guiding principles on which this model is based. And one of those principles, maybe not principles, but like a founding basis for this concept is heavily criticized among the legal community, but we came to the conclusion that those new judges are judges in the sense that they are judges executing the powers of a judge, but they were appointed with the legal and procedural flawed. Hence, it is required to verify each and every of the motions of the National Council of Judiciary since 2017. Another element that was extremely important for us was to secure the right to appeal from such a process. So although we agree, and that was also picked up by the Venice Commission, so the model that the verification is being done by an independent institution. And here I just want to come back to what Katarina said about the role of the National Council of Judiciary, that it should be not only independent from the political influence, but also judicial influence. And I think whatever the new National Council of Judiciary may be in Poland, it will be very hard to keep those two Chinese walls between those two sources of influence. And so the verification can be done by the independent National Council of Judiciary, but the appeal from the negative decision should be heard by the independent court. Another element we are looking into is the stability of the decisions being made by those new judges, because we claim they are still judges, but with that asterisk that they are appointed with the legal flawed. The problems with potential questioning the stability of the decisions and the legality of decision is much smaller. This is simply declaring them non-judges by law. So. But as I said, I just want to be very specific on that. This is not a draft proposal, and this is just a framework which we offer that should be further developed by the authorities. But as I said, this process incorporates so many different perspectives and also powers. Not only like I would say political powers, but also I would say the power to influence the public discussion. Then it's a very long way ahead of us still.
Thank you, Małgorzata. I think we could discuss the topic for another hour, but I think it's the right time to open the floor to the audience and to collect at least 2-3 questions from the participants. So if you feel like asking a question, maybe also making a comment, but that will be a second round, let's use the chat box or raise your hand and we can open the floor for individual questions.
Yes, thank you, Barbara. That sounds great. So would encourage everyone, if you have a question, just like Barbara said, you can raise your hand, ask your question on video or via audio, or you can type your question into the chat. Perhaps whilst we're waiting for a question to come in, and as we have 17 minutes left, I could perhaps use, rather than abuse, my position as a co-moderator and chair to ask a question or perhaps provide a reflection to start with, where I'm really struck, just very specifically, Marcin, on your points about how judges, judicial associations could perhaps be regarded as closer to trade unions. And I think perhaps the reason I'm so struck by this is the judicial culture of the United Kingdom from where I come, where the judiciary is obviously regarded and regards itself as independent from politics. And I think it's been stated before about how the judiciary is a representative of society, even if it is technically, constitutionally, the crown. But I think my main interest is the fact that when it comes to trade unions, I suppose I've always regarded that as, not only protection of labor rights, but also pursuing policy. So pursuing changes to policy. Perhaps to go to that Dawkinian distinction, although we could challenge that, I've always felt the role of judges is about the principle. It's about the downstream issues once policy is being adjudicated upon. So, yes, I just wonder whether you have any reflections upon whether advocating for judges to act more like trade unions could have some kind of influence upon their perception of their role within the legal system when it comes to principle adjudication versus policy, which I think is about governance. Marcin, you'd be free to reflect on that if you'd like, because we're still waiting for any questions that may come in from the audience.
Okay, thank you. So when we are talking about trade unions, it is about recognizing the significant time commitment required from judges who balance association responsibilities with judicial duties. Yes. So to incentivize increased participation from already engaged members, certain guarantees or privileges should accompany union involvement, acknowledging the additional workload undertaken. And maybe it would also give like them this space for that. And when we are talking about judicial independence, I think that it is perceived differently in Western Europe, where there are strong guarantees for checks and balances. And as we could see how fragile they are in such countries like Poland and Hungary. I'm not talking about Hungary specifically, but in Poland, nobody believed in those changes that were happening like one by one. Everybody was so surprised in the beginning that it just happened. Yes, like starting with the Constitutional Tribunal. So taking off all possible guarantees of judicial independence, it just was happening. Yes, we were like witnesses of this, and of course, silent judges was one of the options. Yes, of course, I agree. Like I said to Israeli colleagues, if maybe because it's completely different situation what they have. They have really strong guarantees within the system, like the Attorney General and also the lawyers that are employed by the government. They are independent and they could stop unconstitutional changes on their way within the government. But something like this was not possible in Poland. Yes, there were many lawyers that supported this judicial overhaul in Poland. Yes, so it wasn't possible. Also, when I was thinking about that, maybe judges wouldn't be forced to resist if there was such a coalition of law professors that would be engaged in explaining, providing with vocabulary and expertise the society. Yes, maybe it wouldn't have been possible, but on the other hand, it was just happening. Yes, so we faced during those 8 years factual attempt against judicial independence. Yes, so these are the changes that might enable judges to speak out, because I finished the professional judicial training, and I wasn't trained to speak out in public to defend judicial independence like nobody. People were just to how to write a judgment. Yes. So this is only one side. The other side is because of these rule of law issues, we cannot start reforming judiciary in order to make it more available to citizens. Yes, to shorten the length of proceedings, to digitalize, because we cannot like focus on what is the most important for the citizen, that the court will deal in a prompt way with the cases. Yes, that they will have a fair trial, fair hearing by the court established by law. Yeah, we are still facing with what is the court, and we cannot change anything behind it. Yes, so these were the changes. Yes, so the situation is so complex, but still we are like on the beginning of our way, because we are talking about certain principles, and after they will be after those systemic changes will be made, we'll be able to finally talk about the court proceedings. And of course, we are talking about 3,000 judges. Yes, so it will be very challenging.
Absolutely. Thank you so much, Marcin. Very interesting again. Like the Israel point struck me because we saw protests about rules around the judiciary there. And also what you were saying about how the crisis emerged. I think I'd really like to continue that conversation because I remember in 2015 there were claims from the Law and Justice side that the outgoing SM had engaged in an appointment to the Constitutional Tribunal. And I believe that the European Court of Human Rights did indeed pronounce upon that and considered whether it was unlawful or not. So it'd be really interesting to continue that conversation. But for now, we have a question from Professor Dmitry Kochenov, the rule of law lead, the rule of law work group lead at the DI. And then we have another question from Marcin Shved, and also we have Andras Santos has raised his hand. So Dmitry, I'll hand over to you. Perhaps we can collect those three questions if that's okay, and then we'll have time to finish the Q&A ahead of past. Dmitry, the floor is yours.
Thank you, everybody. It's such a fascinating panel. Really a delight to listen in. I was wondering whether we could extrapolate all what has been discussed to the supranational and international level. To what extent do the same standards that the Venice Commission would recommend and that we would presume flow from Article 6 ECHR actually apply to the European Court of Human Rights itself and the European Court of Justice? I presume we would come up with a list of some kind of deviations from the general standard, and then what should be put on the list and why. And I'm asking this in particular in the context of the ongoing or just finished debate that EU Law Life was hosting concerning Article 255 committee and appointments to the European Court of Justice. Could we end up with a Court of Justice which is facing similar dilemmas? Of course, not 3,000 judges, but still.
Thank you so much, Dmitry. I'd perhaps open the floor if anyone wanted to reflect on that, but we'll collect the last two questions as well first. So perhaps I can hand straight over to Marcin Shved. Thank you.
Hello, my name is Marcin Shved. I'm from Helsinki Foundation, the University of Warsaw. I have a question to Dr. Mrowicki, but it is also related to what Dr. Shipulova said about the negative aspects of the judicial resistance. So, of course, I agree that judicial resistance was crucial in the fight for the rule of law in Poland during the rule of law and justice party. Nevertheless, isn't there a risk that judges involved in judicial resistance during the fight for the rule of law might cross certain boundaries of public activity permissible for a judge? That they might shift from being impartial judges and apolitical to becoming activists. And for some members of society, they could be perceived as heroes, but for others, they might be associated with particular political party or political faction, which could negatively affect both the perception of judiciary by the society and trust of the society to the judiciary, as well as the legitimacy of the process of the restoring rule of law. Therefore, the question is, how can we set the boundaries of freedom of expression and public activity for judges? Thank you very much.
Thank you so much for such an insightful question. I think we can come to the last of that particular round. I see a hand has gone up. So, Andras, if I could come to you for a question. Thank you so much. And hopefully we can then collect the questions. I see Gregos also has raised his hand. Hopefully we can come back to you. But Andras, the floor is yours.
Thank you so much. A somewhat general question, if I may, in relation to the relationship between the protection of between rule of law protection and systemic fundamental rights protection. The I'm thinking about this in particular because of developments in relation to the new Polish government's asylum policy on the eastern border. Professor Kochenov has obviously worked on that subject. Since we talked about Israel, we have, I mean, in the recent months, we have seen really this extraordinary contrast of the Israeli judiciary on the one hand striking down a constitutional amendment in a country without a formal constitution to protect its independence, and at the same time being a a bystander or even a facilitator to mass atrocity. So how do we, since the rule of law is not meant to be a purely formal or a purely formal sort of system, how do we shape the kind of activity that we do here, rule of law protection, in such a way as to ensure that it flows into strong substantive rights protection? Thank you.
Thank you very much, Anders. Barbara, perhaps I could hand over to you because we obviously only have 5 minutes and we've got one more hand, so I can defer to you on how you'd like to
Maybe
deal.
let's collect the last question and then we give the floors to our speakers.
That sounds great. So, Grzegorz Borkowski, please excuse my Polish pronunciation. Please, the floor is yours.
No, that was perfectly fine. Thank you very much. I mean, I just wanted to ask one question. I don't want to spoil the party because I'm a judge and I'm a member of Justitia, so I'm sort of biased, let's call it. And I also spent 5 years in Albania, and you, Linda, whom you've mentioned, was in my team. So I dealt with vetting quite a lot, and I also just committed guidelines on judicial vetting for CEELI Institute in Prague. So my question is, what is the how do you see the connection between the situation in Poland and the judicial vetting and the extraordinary assessment of judges? Because that was the Helsinki Foundation position from the very beginning, and now we have also position of the Venice Commission. So my point is, having spent 5 years in Albania and having seen more than half of the judges leaving the judiciary, none of them was wrongfully nominated. This is the issue according to the tribunals, the courts in Strasbourg and Luxembourg. So maybe I'm wrong. I see the situation from a different point. My main question is, where do you see the parallel between the situation with vetting of judges? Let's call it Albania, Ukraine, Armenia, now Moldova or any other country, and the situation in Poland when the problem is the composition of the Judicial Council. Thank you very much.
Thank you. Barbara, perhaps we can hand back. Aware of time, but of course it would be great to have.
I think if we have not much time left, if each speaker could choose one question from the one that was asked and try to provide at least a brief answer, we will be extremely grateful. Let's start with Marcin.
Okay, I will try very briefly answer all 3 questions that I can answer, but very briefly. Like first, Marcin Szwed, negative aspects of judicial resistance. I'm aware of that, and I was writing about it in this book, and I also was asking judges. There were boundaries that they were crossed. They felt more political activists or judges. Did it influence their judicial work? Yes. And of course, when I was talking about it in Israel, everybody was like, how could they do it? Like there is a certain boundaries that the judges should not cross. And I will say it will be that. For me, of course, the limit is the freedom of expression that was enshrined in those judgments. I mean, speaking out when the independence is in threat is their duty. So when they are speaking out about the judiciary, this is still within their freedom of expression. And Yaniv Roznai, Professor Roznai, who was asked about that, he said something like this, that he would prefer to be judged by a judge that was involved in resistance, that risked his or her professional career for values, than by those who refrain from that because of different calculation. Yes, so this is what he said. The second question was about in Israel. There is interesting article of Professor Adam Shinar, and it was like very fresh in German law journal about judicial overhaul the resistance of law professors, and of course what happened in Gaza. So it's not similar. The power that was behind this resistance against judicial overhaul was not reshaped into defending fundamental rights. Yes. And the last question, Grzegorz Borkowski. I don't see that. I share your view. I don't see that connection. I also think that there are currently no existing standards that would be applicable to the situation we face in Poland. But we are asking international institutions in order to have voices to take into account, like important expertise to take into account during our reform. Thank you.
Thank you. Katarina?
Thank you. I will also try to be very brief. So one question on negative aspects was directed also to me. I would be a little bit careful. I think we now hear a lot of hypotheses about causal links between how public views the courts and how public trust is formed, and vis-a-vis how courts communicate, how judges act off the bench. We are actually not sure how this public trust and confidence in courts is built. Sociologists are telling us lawyers that we should read the literature there is there on public trust for ages. That is actually usually just reflection of how people think about state and state institutions. So I think to be able to answer, I share the worries. But on the other hand, I also do think that we need more systemic thinking and understanding what's really the role of judges in democratic society and to what extent public should understand what's the role of these judges. Because I think we are going from the fact that they should only decide and interpret the letter of the law to the sudden expectations that they are guardians of democracy. And if you name them guardians of democracy, then obviously you expect something else from them, right? So, and I think really there is a huge gap in how we really understand, how judges themselves understand this role. And without that, I would be very hesitant to drive strict results of what their behavior might show us. To what Dimitri was asking, I think we actually do know that some of the Venice Commission and even ECTHR standards do not apply to or let's say it like this. If we were to judge some of the elements of self-governance of the ECTHR and CJEU, we do know that they would not pass the tests of what the Venice Commission and these two courts are developing in the case law. And if I'm correct, then CJEU actually explicitly said that the concept of tribunal it is applying to domestic courts does not apply to it because it's the court sui generis. So there you go. Yeah. And in terms of judicial vetting and illustrations, I completely understand how these concepts are usually and mechanisms are used to different situations, judicial corruption, explicit collaboration with the regime. So it's tricky. I would just like to point that there are different types of vetting and different types of illustrations. If you look at how it was implemented in individual countries, you can see that illustration itself fulfills many purposes. I can imagine that if we cannot organize retention elections or somehow reappoint to establish legitimacy of some of the judges, if we do not want to get rid of all of them, positive or illustration, acclamation or statement might actually be one of the way how you work with those judges that were appointed by the regime if you want to allow them to simply state whether they acted independently even though they were appointed by the non-legitimate National Council of the Judiciary. But yes, it is tricky and problematic, but there are different mechanisms under the term illustration and vetting.
Thank you, Katarina. And now Małgorzata.
So maybe I will start where Katarina left it, and just coming back to the question of Judge Borkowski. I just want to underline it very strictly that it's not our intention whatsoever to simply use any mechanism that was already somewhere else developed and simply copy-paste it to the Polish context. I think I spoke about it several times already today, that the situation in Poland is very, very unique. And when we look into the cases that may not be similar, but that may tackle with some of the problems that we are seeing in Poland, Our issue is not actually to find the silver bullet coming from that countries and to have them installed in the Polish system, but rather look at the entire process and what kind of international standards was developed and lessons learned from these operations. So, for example, there is an entire body of jurisprudence concerning the independence of judiciary coming from Ukraine or Albania, for that matter. That could be a guiding principle for what kind of mechanisms we are trying to develop in Poland, and also the part that Helsinki Foundation suggests. So this is our thinking behind that. But I absolutely agree that it's a little bit comparing apples to oranges in those two cases. And I absolutely agree with what Katerina said, that every of those problems will call for new different solutions. And there are different forms. And I agree with you when you said that there are different forms of vetting and illustrations, but I'm not aware of any other country with similar problems where judges were simply excluded from the benches ex lege in kind of the transitional justice to the matter. So I think that the international experience can bring a lot to the table, but of course it won't be the decisive factor. So that's the first thing. Second thing, coming to the question of Professor Kochenov. Well, I think that there are many ways to answer this question and how to argue those points. But I would say that when we talk about the rule of law and the legality of the composing of maybe another way, rule of law and the independence of the judiciary system, it's not only the matter of how those judges are being appointed. Of course, it's important, and the Polish case brings a lot of experience to that matter, but it's also the issue of perception of the independence of those institutions. And I think in the case of the European Court of Human Rights or the European Court of Justice, regardless how, I would say, politically influenced are these processes, still those two courts do enjoy rather vast prestige and respect in different countries. I think there might be some changes to that depending on the evolution of both the Council of Europe and the EU. But at the moment, I would assess this risk as relatively low. And that leads me to the final point mentioned by Andres. What is the interconnection between the rule of law protection and the new migration policy, and the continuation of pushbacks and allowing the humanitarian crisis at the Polish border to be continued there? I would say that I think one of the mistakes we are doing as a legal community is that we are over promoting the language of the rule of law. Many of those problems, including the problems of the independence of judges and the composition of the courts, could be also explained in the language of human rights. In the end of the day, the composition of the court is nothing else like the right to fair trial before the court established by law. But for the last 8 years, we see the growing trend, the super popular trend of the rule of law that becomes some sort of a buzzword to that matter. And this is also the question for the civil society as such. How do we restart promoting the human rights for all, after that democratic change?
Thank you, Małgorzata. I think your last sentences sound like invitation for the next year edition to discuss Wałęsa case. And that refers slightly to a question in the chat box from Dimitri asking about the GDR judges being all removed or fired after in the early 90s. But at the same time, what often comes up in the discussion about the current situation in Poland is what happened with the Polish judges after the communist period, and whether we can actually compare those two situations, whether we can compare 1989 and 2024. I would like to thank, first of all, the speakers so that you spend your time, your energy, and you discuss this quite complicated issue dealing with the rule of law. But also, you were willing to discuss your work in the topic. I would also like to thank all the audience for your participation and for your questions. I really feel that the question about the rule of law as a living concept was proved today to be absolutely a fair question and a fair topic of our work in the rule of law clinic. And now I would pass the floor to Oliver for his part of conclusions.
Yes, thank you so much, Barbara. Just to echo, thank you so much to all our panelists, Marcin, Katarina, and Małgorzata. Thank you so much to everyone in the audience for your questions and your patience in allowing us to have 10 minutes of stoppage time. I think that's within FIFA regulations, so that's fine. And I will say that we will be continuing this theme of engagement on RevDem, the Review of Democracy. So that's the online live platform of the CEU Democracy Institute, collaborating, of course, with the Rule of Law Work Group led by Dmitry Kochinov and Rule of Law Clinic, led by Barbara. So please follow RevDem to continue these conversations. There will be a recording available, and so we will be in touch about that. So thank you so much, everyone, and have a wonderful evening.